ephemeral than real. That's going to be the answer to that particular point.
You're coming back to that, are you?
I'm coming back to that. I'm going to summarise all of those when we come back to dissolution.
I'm particularly interested in the briefing paper we have on the prorogation and the role of the Crown.
And so we respectfully submit, if you keep our case to hand and have the judgment of the divisional court below, which you probably have in hard copy and loose, I'm not sure where that's gone in the bundle. We respectfully submit that their conclusion at paragraph 42 the first sentence of 42 was correct. As is their analysis in paragraphs 43 to 46, setting out effectively the quotes that I've taken you to in our case, as supporting that proposition. So that's the second proposition. The third proposition is that the rationale for non-justiciability of that type of decision, in other words, of political or high policy decisions, is twofold. First, there are no judicial or manageable standards, to take that phraseology from, I think originally it was Butts, but I think originally in Butts was taken from the US Supreme Court judgments. There are no manageable or judicial standards against which to test the lawfulness of decisions engaging political or high policy considerations.
I think it was taken, Sir James, from a rather different principle, which was the United States political question doctrine.
Well, I think you're right, and I'll go back on all the history of that because it was subject to some analysis in those Crown Act of State cases that the Supreme Court considered, which I know you're very familiar with from the Iraqi litigation. And so we respectfully submit that the divisional court, if you still have that to hand, was also right.
Could you just give me the reference to, you'll appreciate, Sir James, that my computer isn't working. So if and when you actually refer me to any of the documents, I'm going to be in trouble.
Right.
But never mind, maybe we'll get it working before you do that.
Right.
I've got the hard copies of everything you referred to so far, but could you just remind me of the paragraph number in the divisional court's judgment which you were commending before I got into trouble with my computer?
Yes, I think it was 42,
Right.
with the analysis that follows of the case law in 43 to 46. But those quotations are the ones that I've already taken you to in our case. So. And for no manageable or judicial standards or judicial or manageable standards, the passage in the divisional court's judgment I was recommending was paragraph 47, particularly the second sentence. That's the first of the rationale for the non-justiciability of political issues or political decision-making. The second is the one I mentioned in the context of the discussion on proportionality, which is that it would not be constitutionally appropriate for the courts to seek to do so. That is because the exercise of the particular power is appropriate for political, not judicial resolution and control, and that is fundamentally based on the separation of powers, which is an absolutely fundamental constitutional principle, as you are aware. And we respectfully submit that both of those rationale, the twin rationale, were pulled together in the Shergill case. And sorry to jump between the judgment and our case, but if you go back to our case and go to paragraph 58 for that purpose, in the judgment of the joint judgment of laws Newberg, Assumption and Hodge, you will see...
It is fair to say, is it not, Sir James, that the essay on justiciability, which is contained within that judgment, is not really the ratio in that case?
that is...
Is that a fair comment?
That is not merely a fair comment, but an entirely accurate one. I suspect it may be an example of a temptation being utterly irresistible.
We'll have to bear that in mind, Sir James, will we not?
You do. There was the smidgen of a hook for non-justiciability analysis, but quite of that breadth and intellectual force may be a different question. My lady, I rely on it even if strictly obiter, on the basis that, as Lord Bingham, I think, once said, there is obiter and there is obiter. And this is a passage which we respectfully submit does properly encapsulate the twin rationales that appear from the case law and is a crisp summary. What the court there said, or the majority judgment there said, was that the issue was non-justiciable because it was political. It was political for two reasons. One was that it trespassed on the proper province of the executive as the organ of the state charged with the conduct of foreign relations. The lack of judicial or manageable standards was the other reason why it was political. So you get both strands in the single helpful quotation. So those are the three core rationale, the three core principles or propositions we take from that case law.
Well, do you accept, Sir James, that it is for the court to decide what the limits or the extent of the prerogative power are?
My lord, I do. I do.
And do you further accept that the prerogative powers are constrained by overarching fundamental rights?
My lord, in some circumstances they are.
Established principles. So there are constraints to the power, and it is the purpose and role of the court to consider what those constraints are and whether they've been exceeded.
It is.
Yeah.
I don't seek to deny that. I think my learned friend sought to rely below on, not so much here, but on the rule of law as supporting his case. We respectfully submit precisely for the reasons that my lord has just given. The rule of law does not advance his case at all, because we have always accepted that it is for the court to decide all sorts of issues relating to the prerogative, including whether it continues to exist in the face of legislative intervention and what the limits of a non-justiciability principle should be.
Would you accept that the exercise of the power to prorogue Parliament has the potential to affect or undermine Parliament's ability to carry out its constitutional function of holding the executive to account?
My lord, by definition, I'm not sure I'd accept it in exactly those terms because I'd be accused of accepting a contentious proposition, but by definition, prorogation, and it's a point that I will come back to, has the effects that it has. So the bills that were previously before Parliament fall, they can be reintroduced, so that parliamentary questions cannot be asked, so that the parliamentary committees do not sit. So, of course, to that extent, it has the effects that it has. That my submission will be that despite those features, this is a well-established constitutional function, exercisable and to be exercised by the executive, and the question remains whether there are, to go back to the rationale identified in Shergill, whether there are judicial or manageable standards against which the sort of political judgments that are inevitably interwoven into decisions to prorogate, whether there are such standards, I'm going to come to analyse that, and also whether it is, as a matter of constitutional propriety, appropriate for those controls to be exercised by the courts as opposed ultimately to the body to which the executive is ultimately accountable, namely Parliament.
I take it then that you wouldn't accept the submission made in the fifth intervener's latest response, I don't know whether you've read it, at paragraph 8, that the exercise of the power with the aim or effect of frustrating the discharge of the sovereign role of Parliament is out with the scope of the power.
It begs the question. That's the issue.
If it has that effect and it has that purpose, is it out with
I don't know. My submission is that these are political judgments, but I'm going to develop those submissions, and that is essentially the argument that is going to be developed, is whether that proposition is right or wrong.
Right. Well, we'll look forward to that.
We've started at least. My ladies, my lord, those are the three propositions we take from the case law. Lord Pannick submits, if I've understood the submission correctly, that prerogative powers are effectively justiciable because they involve the exercise of executive power. But my submission in answer to that, if that is the case that is made, it was certainly the case that was made overtly below and appears to underlie many of his submissions here, if that is a submission that is made, the principle we submit is not that all exercises of power or all exercises of prerogative power are justiciable by definition, in effect because they're exercises of power. The principle is that justiciability depends on subject matter. For all the reasons that I've taken you through and supported by all the case law, including the judgment of Lord Carnwath, I think it was, in the Youssef case between paras 24 and 26, analysed by the Divisional Court in their judgment at 37 to 38, if your computer is back up and running. My learned friend Lord Pannick's principle would also be far too broad, we submit. It would deny the possibility that some subject matters may indeed be unsuitable for judicial intervention for either of the two reasons that were identified in Shergill, and it's directly contrary to long and high authority. And it is to be noted throughout these submissions that my learned friend Lord Pannick's case, focusing as it did on impropriety of purpose, does not seek to, or nor could it, cut down the bases of judicial review. He says that this prerogative power is subject to judicial review on all of the traditional bases: rationality, relevant and irrelevant consideration, improper purpose. All of those controls, he says, can be exercised over decisions by the executive to prorogue Parliament. And I'll come to the question as to whether that can possibly be right. And we submit that the three propositions that I identified, with the possibility, even in public law and even in relation to prerogative power, of some non-justiciability cutout, is positively consistent with the rule of law, not merely for the reason that I gave in discussion a moment ago with Lord Kerr, accepting that it was for the court to set the boundaries of non-justiciability, but also for the separate reason that I touched on earlier, which is that the separation of powers is at the heart of the rule of law and is respected by the courts and underpins the second of the rationale for non-justiciability, namely constitutional propriety. Who should make the decision under our constitutional arrangements? My learned friend Lord Pannick also suggests that the list, the famous list from GCHQ onwards of those examples of powers that were non-justiciable, including dissolution, but also foreign policy and so on, that the world and the case law has moved on since that list was first set out. And that is true. It has indeed moved on. But none of that moving on has created the principled approach for which he contends, namely that a power is judicially reviewable irrespective of non-justiciability just because it involves the exercise of executive power. None of that case law has come close to establishing that proposition. Indeed, that proposition, as I've indicated, is positively inconsistent, not merely with the older authorities, but with the newer ones, including Youssef, paras 24 to 26, and indeed a case relied on quite heavily in my learned friend's written submissions, the Abbasi case, in which some legitimate expectation control was exercised, but the court was concerned to make absolutely clear that there were still what the court described as forbidden territory. There was still forbidden territory, even in the foreign relations sphere. The second
also related to a particular rights of an individual who was being
that was the other point I was going to come to. Those developments, and it comes back perhaps to a point that my Lord Kerr was putting to me as well, those cases, that development tends to have occurred in almost all, if not all of those cases, where those subject matter areas crossed into or directly affected or abutted on individual rights. And there's no suggestion that we are in that territory here. You'll all remember, or many of you will remember, in Miller 1, that being the centrepiece of the argument, Lord Pannick's compelling allusion to the bullet being fired from the gun and then inevitably hitting the right target, as it were. But that is not this case. We are here dealing with...
I don't think Lord Carnwell thought that was a compelling analogy.
He was, as I recall, he was in a minority.
Yes, but I think I was right in thinking that it was rather doubtful that they depended on the proposition that the Article 15 notice couldn't be withdrawn, which we now know to be wrong. But
Right, we were all operating on certain assumptions in that case, as we all recall as well. But the more serious point is that case law, where those areas have been eaten into foreign policy, matters of that kind, where that list in GCHQ has been impinged upon, the impinging is almost invariably because there is a direct effect on individual rights, which we're not dealing with here. So that's the basic position in principle we respectfully submit, and our submission, my submission to the court, is that decisions about prorogation are squarely or paradigmatically within that political or high policy sphere and within the key rationale for non-justiciability. And I start, if I may, with 4 points about the general position, prorogation generally, and then I'm going to test it, if I may, against the present circumstances that we have here. And the first of those 4 general points is that as a species of decision, prorogation decisions are inherently and fundamentally political in nature. They will involve considerations about how most efficiently and effectively to manage the conduct of the government's business, including specifically its legislative agenda in Parliament. And those sorts of considerations are inevitably shot through with assessments of a political kind. One could name any number of them, but including how most effectively to secure the government of the day's political and legislative objectives and agenda, with all of the aspects that brings in modern politics, including presentational. Whether and when it might be appropriate to terminate or interrupt existing business, including the prevention of bills in the course of passage and the setting of a new legislative agenda in a Queen's speech, the interval between parliamentary sessions and whether that period should be extended, whether a new Queen's speech with a new, differently focused national and parliamentary and legislative agenda should be set, and how long would be needed and desirable, in the government's view, for the preparation of that new agenda. That is, we submit, the business of politics. Both the government of the day and the opposition, pursuing its proper function of doing everything it can to attack and challenge government and its policies, they both, of course, have their own political agendas, their own perceptions of what will and will not operate to their political advantage. And the ultimate weaponry, of course, remains in the hands of Parliament. Motions of no confidence, 2/3 voting for an election under the Fixed Term Parliaments Act, all the decisions, all the debates, all the parliamentary business that we've seen in the newspapers in recent weeks. This is, we submit, therefore, the territory of political judgment, not legal standards, the point we respectfully submit that lay at the heart of Lord Justice Sales's reasoning, as he then was, in the Maclean case. There are, to take Lord Bingham's phrase, no predetermined mechanistic rules. You'll remember the quotation drawing that distinction between legislative control and political judgment in Robinson. Just at heart, political judgments, with a whole variety of matters, including perceived political advantage, as part of that parliamentary and day-to-day governmental cut and thrust that feed into those decisions. And that we respectfully submit, that basic and fundamental nature of these sorts of decisions is illustrated by the history of prorogations, some of which we've captured or sought to capture in our case at paragraph 71.
Are we being asked to inquire into a political decision, or are we being asked to determine whether it collides with a precious legal principle?
My Lord, no one, I think in answer to that, no one on our side would dispute the precious nature of the impropriety of purpose principle. It's a well-established principle. It's from Padfield onwards, you have it enshrined in public law. So no one is querying that. The question is how and whether it can operate in the context of this particular decision-making, this type of decision-making. And you've seen from the case law that some otherwise precious principles of public law have to give way. You've also seen from the case law that non-justiciability operates just as much in public law as it does in other spheres of law. So I think my answer to my Lord's question would be to accept the precious nature of that principle, but nevertheless to say the question remains. Can it operate? Can the other principles, which are equally precious, rationality, relevant
Actually, I mean, you've referred to the principle that I was referring to as improper purpose. I was thinking of a bigger one. I mean, if there's anybody who is better placed to defend parliamentary sovereignty, the legal principle of parliamentary sovereignty, it is us here. And it was that principle that I had in mind when I said, does this political decision collide with something which we are duty-bound to uphold?
My Lord, my answer to that is a slightly different one. I'm sorry, I've misunderstood the question. My answer to that is going to be a slightly different one. I've got a section in the submissions specifically about parliamentary sovereignty, but to flag the nature of the answer that I'm going to be giving to my Lord's question when I get there and do it in detail, parliamentary sovereignty, of course, is a precious principle, but it all depends on what it means. What aspect of parliamentary sovereignty, what aspect of parliamentary business are you actually dealing with? It's no good simply turning up and shouting about parliamentary sovereignty, because parliamentary sovereignty means a number of different things. Paradigmatically, parliamentary sovereignty means that Parliament can make and unmake its own laws, and that when it does pass primary legislation, the other pillars of the state, including the courts and the executive, bow to it. So the
you would say it's as limited as that?
I'm going to say that those are the classic features of parliamentary sovereignty, and then I'm going to analyse whether or not it is truly an aspect of parliamentary sovereignty for prorogation to be controlled in this way so as to engage the concerns of the court. So again, I accept the precious nature of the principle, and my argument in my submission is going to be you need to be very careful before that phrase is, as it were, too widely and too generally bandied about without actually thinking about what it means in the particular context that we're dealing with here. That's going to be the answer.
Thank you.
I don't require an answer at the moment, Sir James, but just to foreshadow my concern about that argument, just to take an extreme example, let us suppose the Prime Minister decided, for political reasons, which you say are perfectly valid, political reasons that he did want to stifle debate, and he did want to avoid scrutiny of his actions, particularly in the contemporary situation that we find ourselves. And he decided to prorogue for 1 year. How would that, well, don't answer now, but that is exercising me at the moment.
It is, and that was the glove thrown down by Lord Bannock at the end of his submissions. How do you deal with that possibility? It's to some extent in the same box as the question my Lord put to Lord Keane yesterday about bribery, the bribery and corruption, the extreme example, prorogation forever. Does that not indicate, is the submission as I understand it, does that not indicate there must be some form of judicial control? And again, I'll come back to it, but a part at least of the answer is to remind the court of I think it was the Canadian Supreme Court who said be very careful about establishing principles by testing them against extreme circumstances.
Not exactly unconventional to do that, is it?
Well, my Lord, there is caution required, we respectfully submit. That isn't our case.
Well,
And there are controls that can be exercised against extreme length, including in particular the intensely practical point that the armed forces need discipline and the government needs money to operate. But ultimately the controls are political. I echo and do not retreat in any way from the answer given to you by Lord Keane yesterday, which is that their political controls. And ultimately, it's open to Parliament to exercise control in all of those extreme situations over the government.
Would the hands-off approach that you advocate extend if the prorogation occurred in the face of a contrary statute?
Of a contrary
statute, if there was a statutory provision requiring Parliament,
Lord, no.
Parliament to be there at a certain date.
Certainly not. And we place positive reliance, it's a point I'm going to develop, as you understand, on, for example, Section 3 of the Northern Ireland legislation, which I'll come back to.
Yes, I'd be very interested to have the government's explanation on that section, but you are accepting that if the government acts illegally by defying a statute, in that context, the courts could intervene.
I certainly do, because it's primary legislation, and that will be fulfilling their paradigm responsibility. It comes back in a way to the example of the Human Rights Act.
But you say it doesn't follow from that you get the whole gamut of judicial review principles.
I do, because all that illustrates is the prime and first principle of parliamentary sovereignty.
Yes.
Namely, that all other organs of the state bow to the express will of Parliament.
So a prorogation is justiciable in that particular context.
Well, my lord, the court will be enforcing primary legislation, which is its function, non sequitur. So my lord has a submission right, yes, but non sequitur is the answer.
Precisely.
So the first of the four general points I was making, inherently and fundamentally political. Secondly, they concern the sittings and the sessions of Parliament, closely connected to the business of Parliament, which we respectfully submit is, and it perhaps echoes the discussion we've just been having, the province of Parliament. We're dealing here with the Prime Minister's power to regulate a Parliament that is responsible for his tenure and to which he is accountable, for example, through a no-confidence motion, and through the other mechanisms that now exist in statutes such as the Fixed Term Parliament Act. But no confidence motion is always there, is always available to the House as the ultimate, as it were, nuclear control weapon. Now, whether or not the opposition or the government are in that territory, I include the government given the times we're in, are going to operate that weaponry, is a matter for Parliament. There is at most a flexible convention that there is a parliamentary session each year. But as you know from recent times, that is truly flexible. The current session, ended by this prorogation, was the longest for many, many years and extended, I think, over 2.5 years. And my submission is that the common law does not regulate and could not regulate the scheduling of parliamentary proceedings. And of course, Parliament can decide, and has decided in some specific contexts, to regulate this by legislative provision. The judgments involved in it doing so, I respectfully emphasise, and this goes to the constitutional propriety issue, are paradigmatically legislative. When should that control be exercised? In what circumstances? How should Parliament be recalled? For what period? For what purpose? How is it meant to work when that happens? Those are legislative judgments, ultimately. And we've given you in the case, if you still have it to hand, at paragraph 28, examples of other legislation, apart from the one that I'm going to come back to in 1 second, but other examples of legislative intervention of precisely that kind. Pretty much always in standard form, as you see, requiring Parliament, in effect, to be recalled if it stands adjourned or prorogued at a particular point in time. But you see that Section 3 of the Northern Ireland legislation, with which you're very familiar, you will see that that is, as it were, but a recent example of Parliament doing precisely that thing.
You'll be coming on, I take it, to explain how the prorogation doesn't cut across Section 3.2a.
Yes, I will. I will. Let me just check that I will. I'm very happy to do that now, if that would help, my lord.
I don't want to take you out of order.
certainly
It's
going to-
something I want. Like,
Yes. I'm certainly going to come to it, and I know that Lady Black was interested in that yesterday as well, so I will try anyway. Perhaps if I can pick it up then, so I don't lose the flow of it, if I may. But the very recent example is the one mentioned in the next paragraph of the case, which is Section 3. Precisely how it works we'll come to, but it is an example of Parliament deciding that in certain circumstances, even if there's prorogation, it's going to require Parliament to be recalled. And the provision is set out in paragraph 29 of the case, and the effect of it is summarised in paragraph 30 of the case. But it applies, I emphasise at this stage, I'll come back to its significance in a moment, but I emphasise at this stage that it applies to control the sittings of Parliament if Parliament stands prorogued. That's done by primary legislation.
yeah.
The third general point is the parallel with dissolution. And we've dealt with that in our case between paragraphs 82 and 85. And the position we respectfully submit in relation to that is this. In the days when dissolution was subject to the prerogative, in other words, pre-Fixed Term Parliament Act, it was regularly singled out as a core example of a prerogative power whose subject matter rendered it political and thus non-justiciable. If you still have the case there, three at least quotations on that, citing it as an example of that. Lord Bingham, in our case at paragraph 66, I think I drew attention to that when you first looked at it in the Robinson case. You see about 5 lines up from the bottom of the quotation in brackets, whether and when to seek a dissolution, for example. Lord Roskill, in our case at paragraph 49, in the GCHQ case. And you see the dissolution towards the end of the line, about halfway through that quote, in the long list of things that are non-justiciable. And Lord Justice Taylor, if you cast your eye down the case to paragraph 52 and the quotation from Everett. Again, it's about halfway through the quote. He mentions making treaties, making war, dissolving Parliament. And our submission is that there is, for present purposes, no distinction between dissolution and prorogation. There is no distinction because the underlying basis for the dissolution example, as explained in that case law, of a subject matter area that would be non-justiciable, was the lack of political standards and the constitutional propriety of politicians deciding political issues. And it's impossible to see why those should not apply equally to prorogation. It is not distinguished from prorogation by contending, we submit, that the dissolution would be a personal prerogative, unlike prorogation. In both contexts, Her Majesty the Queen will act on advice from ministers. Whether prorogation or dissolution is in fact personal, and if so when, is governed in any event by convention and not by law, and, it may be said now, is the subject of some considerable academic debate. I'm not going to go to it now, but you have in the supplementary authorities bundle behind tab 28, I think it's electronic page 491, Professor Twomey's analysis of all the various examples. He has a whole chapter on prorogation, which we've given you, and a series of examples across Commonwealth countries in which it's been done, which makes for, it may be said, jolly interesting reading, not least because you can see from that the sort of circumstances in which prorogation was ordered. You can see governors and governor-generals getting involved and deciding they're going to delay for 2 hours before announcing whether they're going to accept it to indicate that they were exercising a discretion.
Could you just give the reference to that
My lady,
again?
I'm so
Is it
I
from
think
your authorities bundle or
it's
the
in
Cherry
supplementary authorities bundle.
Supplementary.
I
Well,
don't
you've
know,
got two of those.
We've got two. It's the first one. I don't think anyone's yet referred to the second one, but it's in the first one, tab 28, and I think it's electronic 491.
I'll give it a go. Well, it's headed 8, prorogation.
Yeah, well, that's very promising then. Yes, that's it.
Good.
As I'm not going to go through it because there's a series of examples of prorogation being used, in many cases, for overtly and obviously political purposes, and indeed for present purposes, indicating that at least in certain circumstances when governors and governor-generals were dealing with these things, they were at least thinking about whether or not they had a discretion or they didn't have a discretion.
But it gets further than that, doesn't it? And I think this is why the briefing paper, which we have at page 169 of the main one, draws on Antome's analysis and gives us, well, the recent 2008 example in Canada, where the Queen's representatives took a very active role. And that paper indeed raises at the end the very question we have before us now, which is whether, if a Prime Minister who didn't have the confidence of the House was to seek prorogation, whether the Queen would be bound to accept that.
Well, my Lord, you say the very question we have now. In some ways, that's the very question we don't have now.
Well, it may be. I mean,
because
can we look at that, page 194?
Yes.
I really,
it's in the Miller trial bundle, yes?
in the Miller trial bundle, yes.
Is that the electronic page number?
I don't know what it is. It's a hard page I've got, I think. It's tab 29.
Oh, they're different.
Oh, yes, they are. You had 63, don't you?
I think you had 63, yes.
So they're
250.
258, yes. But, you know, I mean, that deal, you see, under the paragraph, page 1, paragraph 2.2 of that, it deals with the question of authority for prorogation.
I'm
tells
so
us
sorry,
in the
I don't have the reference.
No, I'm sorry, it's in the Miller trial bundle.
Yes.
Which is labelled hearing bundle in
which
our...
is labelled hearing bundle.
Yes.
And it's page 175, hard copy.
Tab 29.
237? 237 electronic. Tab 29.
Yes, thank you very much.
So, sorry, 175 hard.
So which tabs it in?
Tab 27?
Thank you.
29.
29, I'm so sorry, my tabs have been removed. So. My Lord, I'm sorry, I interrupted.
No, it doesn't.
It's the Commons Library briefing
It
on
is.
prorogation. It's extremely helpful.
And very, but it says at paragraph 2.2, second paragraph, whether the Crown must always follow ministerial advice in the context of prorogation is contested, but has not in modern times been tested in the United Kingdom. It then goes on to say that in other Westminster constitutions, it's treated as a reserve power, and that is not. And then it goes on to give us the example, page 182, paragraph 3.1, of the no confidence motion in Canada in 2008, when the Governor-General plays an active role in dealing with the sort of questions of Parliament. And then at the end, page 194, or whatever it is, thirdly, in the absence of a clear statement of confidence in the government, it cannot be said with certainty whether the Crown would follow the prorogation advice of the Prime Minister. The very act of asking the Crown to acquiesce to a lengthy prorogation involves the constitutional monarch in a profoundly political question, which ought probably be resolved by parliamentary means. Now, we have it on the authority of the Leader of the House. In this particular case, the Queen decided that she didn't have any role in the matter. But do we know whether she had seen this, or her advisers had seen this paper?
Well, we don't, and in any event, even if she had, the examples from the Commonwealth, as you will have seen, this is, I think, the stuff of the Twomey article, consider, at least in those contexts, that the reserved power operates only in limited circumstances, including in particular when and if there is a problem reflected in a no confidence motion of the government clinging to power in circumstances where it has no warrant to do so, but not otherwise. So there are all sorts of questions about that.
I think the point I'm concerned about is this. It seems to me it can work both ways. One of the points that Lord Panic makes is there are no checks and balances. You know, there's nothing to stop. If we don't intervene, then there's nothing can be done to stop the Prime Minister dispensing with parliamentary control. Whereas if the case is that in fact there are controls which in principle could be exercised, but as a matter of convention and not, well then it seems to me that may raise a very different situation. And I'm very concerned we don't make the mistake we made. Well, we don't get in a position where we're deciding these major constitutional issues on a basis which may not represent the true position as to the Queen's role.
My Lord, the difficulty perhaps is that, and you'll appreciate that there is some sensitivity around this issue because there are different interests which aren't purely governmental involved. So I think the furthest I can go in relation to that, and I think it is a reflection of what sits in that briefing paper, is that the position in relation to the involvement of any sort of personal prerogative, both whether and if so when, of the sovereign, is a matter of some considerable uncertainty. And the reason I go there for this purpose at this point in the submissions is because the court can't proceed on the assumption that the way you just simply distinguish dissolution is because that does involve some personal prerogative or some personal decision-making by Her Majesty.
In this case, is it the government's position that Her Majesty the Queen had any prerogative power?
My Lord, you've seen the statement of the Leader of the House, and I don't seek to depart from that.
He's making a statement, presumably from a political standpoint.
He is, and I have no instructions and no position on that general constitutional question.
Well, you're not arguing from a legal perspective that there is any prerogative power vested in the Queen.
I'm making no submissions either way on that. For reasons that I hope you'll understand. But the position is, as reflected in the briefing paper, that it's a matter of some uncertainty, some academic debate, some difference of practice in the Commonwealth. The Twomey article is interesting because it illustrates the different circumstances. It has all sorts of echoes for the purpose of this case, not least in illustrating that prorogations have frequently occurred across the Commonwealth scene for nakedly political reasons. Different questions around whether or not, if there is a personal prerogative or personal decision to be made by the representative of the Queen in those contexts. Different questions to be asked around whether or not that applies across the board or only in certain limited circumstances. There's some suggestion in the Twomey article that it's a much narrower group of things where the government has lost the confidence of the relevant legislature. But we are overtly not in that territory here. No one has, despite the opportunity to do so, introduced a motion of no confidence in the government.
Sorry to press on, Mr. James, but underpinning my Lord's question was, in reaction to Lord Pennock's submission, that if the courts aren't the medium by which control can be exercised, then there is none. And my Lord raised the question, well, is that constitutionally correct? Because the Queen, on the view of some commentators, might have a prerogative.
I make no positive submission to that effect.
Thank you.
Just to finish, I mean, that's very helpful, but just to complete, I mean, reading the Twomey chapters, which I think are very interesting, in none of them does it seem to have been seen as a role for judicial review. I mean, I don't think there's any example of precedent for sort of judicial review being used as a substitute for the control by the whatever control is exercised by the
there isn't, and I mean, I suppose the answer, in fairness to the case against us, the answer I'm sure Lord Panic would give to that is, well, that's because no one happened to have gone to court. That issue has not been tested, but we respectfully submit, in agreement with, I think, the thrust of my Lord's question, that it is of at least some interest, particularly given the politically controversial nature of some of those prorogations, that no one has engaged in any attempt to say that this is a matter that could be controlled by the courts.
In fact, I think in Chapter 10 there is some discussion by Professor Twomey of the possibility of involvement of the courts. And what I wanted to ask is, if there are constitutional principles that require to be policed, in our constitution, isn't it more appropriate for the court to do it rather than for the Queen to have to be sucked into what may be decisions with political ramifications?
My Lord, I think you may well be right, and I may well be in a position of happily accepting that proposition, because, as I say, I make no positive case that as part of the bulwark, if that was all that was left, it would be the Queen's personal decision which would provide the constitutional protection. My case, as you'll appreciate, is that the constitutional protections are provided in the political arena by Parliament, by no confidence motions, by all of the matters that govern the tenure of the Prime Minister in our democratic legislature. That's where you find the appropriate form of control, not in the courts. So not merely do I not assert positively that the Queen provides any such constitutional control, but I respectfully submit that there are, nevertheless, the requisite controls provided in that way.
Have we got a chronology anywhere of the events from mid-August?
I don't think so. But we can, I'm sure, produce one if it would be
Just thinking about what time there was in Parliament at various stages. Thank you.
Yes, with that. So I've dealt in that rather roundabout way. I hope that's a helpful discussion, but I've dealt in that rather roundabout way with why we say that it is no ground for distinguishing dissolution as the paradigm example and the echo into prorogation by reference to the personal nature of the prerogative or otherwise, because that's simply not established or certain, as it were. But it's finally no answer to say, as I think my Lord Panic does, well, we now have the Fixed Term Parliament Act. And again, of course, we do have the Fixed Term Parliament Act, but the comparison for relevant purposes is between the dissolution power when it was a prerogative power and the prorogation power as it still is a prerogative power. When the former existed as a prerogative power, that is dissolution, it was non-justiciable. So the question is, why are they distinct for that purpose? And it isn't answered by saying you've got a new legislative regime in place, especially, it might be thought, one which positively preserves but does not otherwise control in Section 6 the prorogation power as a prerogative power. So we respectfully submit that that provides no answer and no distinction between dissolution as the paradigm example or a paradigm example of a political or high policy question. The fourth point I can make very, very shortly in terms of the generality, and that is that this is not a context which is about rights. This is not Miller. This is not Youssef. This is not any of those cases in which the traditionally identified areas of non-justiciability have been eaten into. It is not about rights. Those are the 4 points I wanted to make on the general nature of the power. And I wanted then to test them against the present context and the present circumstances. And I wanted to do that because doing that, we respectfully submit, illustrates the fundamental problems with both judicial standards and propriety in both the design and the application of legal principles and legal controls in this context. The contention by the claimant is that the courts, as it was put by Lord Panic in his written argument, the courts must ensure that Parliament is not prevented from sitting, and that the effect, as he puts it, of prorogation is, quote, seriously to impede Parliament's ability to perform its functions because it will be unable to legislate. And the will of Parliament is engaged, it said, because it is said that Parliament is being prevented from doing that which it would otherwise wish to do. The case in this court is now put on a narrower basis, or focused on a more narrow basis. which is the impropriety or alleged impropriety or illegitimacy of purpose, that purpose being identified as, quote, avoiding the risk of Parliament undermining the policies of the government. And I'll come back to the detail of the way in which it's put, but some initial points, if I may. But first, it is self-evident that prorogation means that Parliament will not sit. No parliamentary questions, no committees, no legislation for as long as it lasts. Whatever the ultimate end sought by any prorogation, whether it simply be a new Queen's speech in as short a time as possible, accelerating the passage of legislation under the Parliaments Act in 1948, wrong-footing the opposition, a desire to focus on the prosecution of war in 1914, the means by which the intended end is to be achieved is the inevitable preventing of debate and those other functions for some period in Parliament. And it's difficult, therefore, we submit, to separate the object and effect of prorogation. Prorogation always necessarily limits the debate that could otherwise occur, and therefore any decision to prorogue is in some sense intended to reduce the time for debate in Parliament. That raises questions of utility of its sitting for particular periods of time. Secondly, some effects flow from the fact of prorogation. In other words, the falling of bills, as an example. And some effects last, parliamentary questions, the sitting of committees and so on, for as long as Parliament is prorogued. Flowing from that, my learned friend Lord Pannick does not attack prorogation per se. He simply attacks prorogation of this length at this political juncture. And there are consequences of that narrowed form of attack. The first is that it is those features of this length at this political juncture which are the focus of the arguments about judicial intervention. And I emphasise that because the constitutional principle that he advocated appeared to be that Parliament must always sit and have opportunities, and have the same opportunities it has when it's in session. Well, that was at least a position until pulled back a bit by a question asked by my Lady Black, and he then reverted to the case run in the divisional court, which was that the period was what was being attacked, and that it should not exceed what he then described as a period that was reasonably necessary for the purpose of the prorogation. So it's important to bear those features of the argument in mind because they condition the questions that the court will have to ask, not least in relation to some of those adverbs, which I'll come back to. The second consequence of him not attacking prorogation just this length at this political juncture is that he can't pray in aid of an improper purpose argument, consequences flowing from the very fact of prorogation. Bills falling is one of those things. They fall because of the fact of prorogation, and he's not attacking that. It's got absolutely nothing to do with the period for which Parliament is prorogued. So the falling of bills is irrelevant for present purposes. We would add, at least the political point, that in any event that falling is temporary. If the new session chooses to pick them up, it can do so. If they form part of the legislative agenda set out in the new Queen's speech, which is an integral part of the way in which democratic government operates in Parliament, then they will be picked up. And if they fall and stay fallen, that is simply a function of the operation of those democratic principles in Parliament.
Sir James, I know you say it's irrelevant, but nevertheless, I don't want to be ignorant. The automatic effect of prorogation is that bills that have not yet passed all stages in Parliament fall. There is a method of preserving, carrying over. Now, as I don't know the precise limits of that, no doubt somewhere in the documentation it will be explained. But my understanding is that if they're carried over, they go over into the new session at the same stage that they were in the previous one.
They do.
Whereas, of course, if they fall without being carried over, they have
again.
to start all over again.
My lady, you're right. You're right.
Oh, good.
You're right. And you will have seen some reference to the bills that might be carried over. And I think it was paragraph 9 of the Da Costa memo that we looked at.
But there is, in fact, only one bill has been carried over.
I'm sure we can check the precise number
Well,
and which one
the
it was.
Public Law Project's recent submission
I'm having it
suggests
whispered in my ear that they're wrong about that, but
They may be. They may
whether
be.
they are or they aren't, we can check. It's a matter of fact.
Thank you.
But we'll make sure. But my lady is right. They do go back to the beginning, as it were. But the option, as I say, remains for the government to make time, for Parliament to make time for those acts that otherwise fell and were not carried over.
It does postpone the debate, and it does postpone the debate, and some may be time critical.
That's possible. All of that is possible. But all of those are just simply functions of Parliament operating. And Parliament can legislate, as we know from recent events, very quickly if it considers that's the appropriate thing to do. So if there is time-critical legislation that Parliament judges needs to be passed time-critically, then that's what it will do. I think my answer to my lady's question.
So, James, I was a bit concerned to hear you say that some of the evidence given in the Public Law Project presentation is wrong. You have actually replied to that in your skeleton in reply, and we've obviously been reading that.
Well, I think it's the latest one. It's the one we got this morning.
Is there? There's
Yes.
another, is there?
I'm so sorry. We have replied to their previous submissions.
Yes. And then they replied to your reply.
Well, then they replied to our reply.
I'm sorry, I
I
haven't
don't know
got-
whether the court's granted permission for them to do that yet, but
But
Yeah.
do you challenge that 5 Brexit bills have fallen completely? And do you challenge that a mass of delegated legislation has got to be in force by the 31st of October, and now can only be in force if the made affirmative procedure is invoked, under which it is made before it is scrutinised?
well, I'm sure that the basic parliamentary procedures by which those time-critical things can be dealt with is not going to be the subject of challenge. But I got the note this morning, and I had my mind slightly on other things this morning.
course.
So I apologise for not having a complete answer to that yet. But it may be appropriate for us to simply check the new note to see how that operates.
Thank
but
you very much.
my principled answer is going to be the same one that I gave to my lady, which is that if Parliament considers that those time-critical pieces of legislation need to be passed time-critically, then they will act accordingly.
Yes.
That's a matter for them.
I mean, but there must be a limit to what Parliament can do, because we all know that parliamentary time is in itself a scarce resource. So it's not as though it's infinitely expandable in the period down to the 31st of October.
It isn't, but no one has sought to make a case that it is, nor could there, I think, impossible to pass the legislation that Parliament requires.
Right,
For
but
whatever
I
purpose.
think what my Lord Wilson was, well, one of the things he was asking you about was the passage of delegated legislation, which will be very important to have in place by the 31st of October if Brexit happens on that date. And on my understanding, that's going to go through without scrutiny in Parliament before it is made, because it has to be made in the period of the prorogation.
Well, I don't know, I'm afraid, having not seen this morning's effort. I'm not,
No, well, I thought that was...
That was in the
earlier.
That's in the original.
but we've got...
That is in the original Public Law Project presentation, to which you have replied.
Yeah, and my Lord, our answer...
If that is said to be wrong, we should be told.
Yeah, well, I'll double-check that. But
Thank you.
my answer of principle is the one that I've given. Of course, Parliament's time isn't infinitely expandable, and they may have to make, ultimately, judgments about which ones are more important than others. But this is, in the end, a matter for them.
Thank you.
Handed a note that 3 bills were carried over. The Birmingham Commonwealth Games Bill being
Yes.
one of them.
That was
The
mentioned.
Sentencing Pre-Consolidation Amendments Bill.
Oh, that was carried over,
And
was
the
it?
High Speed Rail West Midlands Crew Bill.
The Law Commission will be extremely pleased to learn.
Yeah.
Anyway. So those are the points I wanted to make, the initial points I wanted to make. Non-justiciability, as we've seen, is a principle underpinned by the two rationales, the manageable standards and addressing and answering the questions necessary for constitutional propriety. And that does involve, therefore, considering with some specificity what questions the court is actually being invited to and would have to consider for the purpose of all of the JR principles that are said to be in play, including impropriety of purpose, reasonably necessary for the purpose, and so on. And we submit that once those general assertions are actually analysed so that you see the specific areas into which the court is being invited, the features in support of the principle contended for and the nature of the control contended for require decision-making and the formulation of legal controls in relation at least to the following: the length of prorogation, whether this political juncture warrants a longer or a shorter prorogation, whether Parliament would wish to legislate, what range of legitimate purposes for a longer or shorter prorogation there might be, what types or species of political consideration or advantage might operate as legal controls. And just to take those a little bit more fully, there is an immediate problem, and it is that the court tends, in the past has tended, to identify the will of Parliament from enacted legislation. Its meaning and whether it's undermined are judged against that clear and constitutionally appropriate yardstick. That's what the court was doing in Miller 1. Unless and until legislation is in fact enacted, how the court judges whether Parliament would have wished to or would wish to legislate is an entirely uncertain question, because some MPs say so on a head count, or how? How is that question to be determined and answered? It moves away from the sure and only proper guide to parliamentary intention, which is in enacted legislation, we submit, and moves the court, moreover, straight into the territory of political and parliamentary controversy. It's also entirely unclear what scale or nature of controversy would engage the intervention of the court or trigger it to invent controlling mechanisms of that kind over prorogation. The next set of questions surround the length of the prorogation and the sufficiency, to put the same point in a slightly different way, the sufficiency of the opportunity for Parliament to legislate or to oversee. As we know, the challenge does not involve a challenge that requires permanent sitting for obvious reasons, nor could it. The case is that there has been insufficient opportunity afforded to Parliament to legislate or oversee in the context specifically of Brexit, and most specifically in the claim advanced by this claimant for the possibility of a withdrawal without a deal on the 31st of October. But again, that just simply prompts a whole series of unanswerable questions. How is sufficiency of time to facilitate legislation to be judged? How long is needed to hold the government to account over Brexit? And we submit that the points made at paragraph 57 in the Divisional Court's judgment are well made. It is impossible, said the court, for the court to assess by any measurable standard how much time is required, quote, to hold the government to account, including passing legislation that would require the Prime Minister to take steps to avoid the United Kingdom leaving the European Union without an agreement. Is it particular legislation or is it all legislation? What factors justify a longer or a shorter prorogation? And how could the court weigh or assess political judgments of that kind against a legal standard. And again, we respectfully submit, if you still have the Divisional Court's judgment to hand, that the analysis of the Divisional Court at paragraphs 54 and 56, which I'm sure you've read so I don't repeat them, is correct. So those are the sort of questions that surround sufficiency or length, sufficiency of opportunity or length. What about the controlling reasons for the advice? Well, again, they're going to be shot through with political considerations, as history demonstrates. And indeed, it may be entirely or purely for a perceived political advantage. What are the controlling principles there? How is the court to judge what is relevant and irrelevant, what is rational, ultimately, in terms of the decision, and what is not, when it can't weigh those political judgments in the balance in any sensible way? So my learned friend has sought to focus on proper or improper purpose or motivation or effect as an abuse of power, as he puts it, as the controlling principle. Just in relation to abuse of power, we do recommend to the court the quotation from Lord Justice Laws in the Nadaraja case, in our case at paragraph 90, effectively saying, be careful of abuse of power, because that's simply an overarching way of describing public law unlawfulness. It doesn't actually advance the analysis. But however it's precisely put, the essential problem of trying to introduce proper or improper purpose into this prerogative of prorogation territory remains that has been identified already by the courts. That is the significance of the Sandiford decision. Which is in the authorities bundle at tab 32 in bundle 3. And again, I can probably take, I think, the quotations from our case, the quotations of relevance from our case at paragraphs 88 and 89 from the judgments of Lord Carnwath and Lord Mance on the one hand and Lord Sumption on the other. And the key thought, if I may so characterise it, is in the passage from Lord Carnwath's judgment we quote at paragraph 88. They don't stem from any legislative source prerogative powers, nor therefore from any such legislative decision, and there's no external originator who could have imposed an obligation to exercise them in one sense rather than another. They are intrinsic to the Crown, for the Crown to determine whether and how to exercise them in its discretion, effectively pointing up the distinction between a Padfield improper purpose, where you have the statute which you can interpret and use as a guide to parliamentary intention, applying standard principles of courts interpreting legislation to identify purpose, and a power such as the one that was being considered there, and a fortiori the one that was being considered here, where there is no external originator, there is no yardstick against which to judge what is a purpose that promotes the legislation or doesn't promote the legislation. So these cases are fundamentally different from the Padfield line of authority on which this line of argument was founded, for the very reason given in Sandford.
So Sandford was about the no fetter principle.
It was. It was.
So those remarks were addressed to a rather different challenge
to
the government's failure to act. I'm not saying that necessarily makes a difference. I'm just saying that was the situation.
My lady, you're entirely right. My submission should have been that by way of, as it were, analogy into this, those comments in the judgment are equally applicable here. We put up this morning on your desk, and it's probably been lost again in the welter of paper, but a case called the Air Centre, which my Lady Arden may recall. And I do so again, I emphasise, not because it's directly on point, but because it's an illustration of the same Sandiford-type principle in operation. Does the court have that? It was probably loose on your desk this morning. If not, I'm sure we've got more copies.
I'm very sorry.
No, it doesn't matter. We've got more. We've got more.
There is a spare.
Which one?
Yes.
It's come through electronically, so Lord Sales can have my copy.
I've got being handed. Thank you very much.
I don't want to spend long on it, but you will see, if you just cast an eye down the headnote, the context of the case and the facts for relevant purposes. The issue for present purposes was whether the police, if I speak as you read, as it were, was whether the police had the power at common law to ask questions of persons arrested to establish their immigration status on behalf of the Home Office, there being no statutory power for the police to do so. And you see that cast as the issue in paragraph 33 of the judgment. This was a judgment of Lady Arden. It's a recent judgment, so I think still sitting in the Court of Appeal, but recently promoted. Para 33, and the argument, as you see reflected in para 34, was that the police could only exercise their common law powers for a policing purpose, prevention or detection of crime, and not to assist in immigration enforcement. So it was effectively using their powers for an improper purpose by another means. I'm not sure it was quite presented in that way, but that looks like the essence of it. And the Court of Appeal agreed with the High Court that the police had a common law power to do anything an ordinary citizen could do. That's paragraph 38. They then concluded in 39 the additional statutory powers of a police officer over and above those held by the ordinary citizen didn't constrain or restrict those common law powers, 39. And they then concluded that the common law powers were subject to ordinary principles of public law, but couldn't in effect be assessed by reference to purpose. So the key bit for present purposes is really between G and H on page 3012. What they did not have to do, however, is find some specific police power to enable them to do something ordinary citizens can do, nor do we accept the principle that public bodies must exercise their powers for purposes for which their conferrers engaged on the facts. Mr. Milford submits he was for the police, and we agree that this case does not concern any specific statutory power conferred upon the police. The issue is a different and anterior one, namely whether the police can exercise the same non-coercive rights and powers as any other natural person. In other words, whether a common law power was being exercised, where a common law power was being exercised, the Court of Appeal agreed entirely in accordance with that Sandiford principle that the purpose principle had no purchase. It could not be asked the purpose for which the power had been conferred because it wasn't a statutory power conferred for any particular purpose. So that's another illustration of Sandiford in operation, we respectfully submit. I respectfully emphasise that this isn't just about the court making an order or adjudicating to require a particular length of prorogation. I mean, ultimately, you drift pretty close to that in terms of a rationality challenge, if that were to be made, and that hasn't, of course, been shut off. But the court, of course, couldn't do that. But the fact that it couldn't illustrates, we submit, a deeper problem, and the deeper problem is the lack of standards against which to test the standard JR controls. What's relevant and irrelevant, what are proper and improper purposes, what is rational. They all have to be tested against some standard. And back to the rights point, normally what happens when you are dealing with rights or an impingement on fundamental rights, such as when the HRA is engaged, is to examine the impact and what is relevant and irrelevant by reference to their impact on individual rights. So when you're assessing proportionality, for example, is the thing that the government wants to do, is the policy that is being pursued, proportionate to the nature and impact on individual rights that it creates? That's the fundamental question. But you have legal standards at all parts of that analysis. And the same is true, back to the Air Centre and Sandiford, where you have a statute creating the relevant purposes and objectives in legislation that you can interpret. So not merely here are there none, but we submit that the tools for their invention are lacking. What about political advantage or political issues and how all of that plays? Again, in common with Lord Hodge, we understand that it was a common ground that at least some types of political advantage were common ground accepted as permissible. And even Lord Pannick seemed, in the course of his submissions, to accept that some might be. But how is this court to determine whether, and if so what, political advantage points are and are not legitimate? How is it to determine whether this is a relevant or proper consideration without a statutory yardstick of the kind you had in Sanderford? And indeed, in this particular context of parliamentary timetabling and the business of Parliament. And if the assertion is that some are okay and some are not, to go back to the thought that Lord Kerr put to Lord Pannick in argument, well, it depends on the species. How does the court determine which species is good and which species is bad for present purposes of political advantage being pursued? And we respectfully submit in this context also that the judgment of the Divisional Court was correct and principled, including in particular the passage in paragraph 55 of their judgment. We do submit very, very briefly that the example they give, which was the one touched on yesterday, of the 1949 shenanigans, if I'm allowed to call them that is a good example of political advantage. True it is that it involved, for this purpose, the internal politics of the Houses and the battles between the Commons and the Lords, but that is for Parliament to deal with. And the prorogation was being used to advance the government's perception of what the right answer was in that context.
Can I just take up with you, because you just said that was for Parliament to deal with, how it works here? Underpinning your submissions that there is no justiciability here is the existence of another check or balance, that is to say, Parliament. But where proroguing is involved, that necessarily removes at some point Parliament from the picture.
It does.
So how on these facts was that check/balance to be applied?
Because Parliament has the ability to control. I've accepted, because it is clear and obvious, that during prorogation, Parliament cannot legislate, its committees don't operate, you don't get PQs, and all of that. So my lady is right to that extent. But Parliament can control this beforehand.
That's the practical question I'm asking about, and that's why I wanted the
as it did in Section 3, and I'll come to that in a moment, and can control it afterwards. So there are mechanisms of control around the prorogation. Of course, during the prorogation, Parliament is prorogued. So by definition...
Does controlling it afterwards help?
Well, they can pass a motion of no confidence. They can call the government to account when Parliament resumes.
In a time-sensitive setting, how does afterwards help?
Well, if the thing is time-sensitive, then Parliament can and has to react in the time that is left before the time sensitivity runs out.
The thrust of the appellant's case here is that the effect of prorogation is to deprive the Parliament of the opportunity at this critical time, coming up to the 31st of October, of the opportunity to scrutinise the government's actions and to hold the government to account. So a post hoc system of control isn't of much benefit in relation to that, is it?
Well, my Lord, I'm not going to repeat the answer. The answer is that whilst Parliament is prorogued, of course Parliament is not sitting and those species of control cannot be exercised. But we submit that in our facts, if it's a question about our facts, control has been exercised, was exercised, could have been exercised further, and will be exercised on the 14th of October and following.
I'm not sure repeating the answer necessarily gives me the information that I think my lady was asking for, and that is, what is the post hoc system of control? How does that affect what the appellants claim to have been deprived of here?
Well, it goes back to sufficiency of opportunity. There are, when Parliament resumes on the 14th of October, there are, irrespective of the extension provision, which presumably the court will not ignore, which has been passed in the new 2019 Act, so 31st of October may or may not be the deadline, but irrespective of that, and assuming that it is, it still has the period of whatever that number of days is. 17 days.
Sorry, I think maybe I haven't made my question clear. It's the question of a check and balance on the proroguing that I'm asking about. How does, once you've been prorogued and lost that time, how does it help to be able to take it up afterwards?
Well, it depends what is left of the legislative programme. It depends what then happens. It depends what remains time critical. Assume for the sake of argument that there is no time criticality. Parliament can then resume, exercise whatever functions it wishes, and pass whatever legislation it wishes, ask whatever questions it wishes about of the government. It can resume all the forms of control that it exercised beforehand. So if it is time critical, then that question becomes, is there enough time for the legislative programme that needs to be dealt with time critically to be dealt with? And my submission is that even if it's 31:10, there is time, and it's a matter for Parliament and the government to pass whatever legislation they consider necessary.
Returning to the issue raised by my Lord Wilson, the statutory instruments which would not be subjected to parliamentary scrutiny in the normal way and would have to go through a separate process, that would be irremediable, wouldn't it?
Well, my Lord, sorry. I'm being told that we've got a note from our instructing solicitors and departments on that issue.
We'll come back to them.
And we can address that if it's a matter of concern. I know it's been raised twice by you.
Could I ask a slightly different question while there's a pause? Suppose that the government does give reasons for the prorogation, and suppose it is said that because of some incident there needs to be a pause, but then seeks and obtains a prorogation which is much longer than that, so that it could be said that there's no rational connection between the end, which was stated to be the purpose. Are you saying that the courts would have no role in that situation?
My lady, I am. I am, because that is in essence testing the sufficiency of the period.
Well, it's put at a very low test where there's no rational connection.
Yeah. I am. I mean, you understand, our case is that this is political territory. This is not, for all the reasons I've given, about judging the sufficiency and how you judge the sufficiency of opportunity or the length. This is not territory in which there are appropriate and proper legal standards.
Even though the government has specified the purpose?
Even though, because they will specify reasons, no doubt, for political reasons. And that is the form in which they are to be judged and in which they are to be controlled. I mean, it comes in essence to the case that my learned friend Lord Panning eventually ran in answer to Lady Black's question, which is it's got to be the shortest possible time or no more than is reasonably necessary for the purpose, as he asserted it, of closing one's parliamentary session and opening another, or the objective of doing a Queen's speech. Now, the problem with that way of putting the case is that the one that Lord Keane mentioned yesterday, which I won't go back into, based on the 1867 Act, which is that you can prorogue Parliament when it's summoned to meet In other words, postpone the first Queen's speech, and when it's already prorogued, you can do a double prorogation. So the basic purpose needs to be identified and cannot be shrunk to the time needed to produce a Queen's speech, with the court having to make judgments about how long is necessary for that purpose.
That would take an extra order in council. You can't just say that. You'd have to advise.
Yes, you could have a double prorogation. You could do it twice. Yes. But my only real point is that it's not just restricted to how long do you need to do a Queen's speech, because prorogation can exist in a whole variety of different contexts. And
it does go to overcome this problem that you can't tell the purpose. If the government has said what the purpose is, and still there's no rational connection, what's the objection to the court intervening?
well, my lady, all the ones that I've identified. Yeah, I'm not sure it advances more than that. And we submit that it is for the government to regulate the sessions of Parliament, the sittings of Parliament, while it's in existence, subject to the specific constraints that exist. And even if the purpose were to prepare for a Queen's speech pure and simple, and you could restrict it to that, the Divisional Court again addressed that and dealt with the difficulties of a court trying to assess whether the period for preparation of a Queen's speech should properly be 5 weeks, 4 weeks, or 3 weeks. Simply impossible, they concluded. We respectfully submit correctly. So our basic submission is both the formulation and design of the principal control over parliamentary sittings simply raises questions the courts cannot answer by reference to what standards does it do it when you actually properly analyse what my learned friend is contending for, which is all about sufficiency of length or sufficiency of opportunity. And it also raises the other basis of non-justiciability. Is it appropriate for the court to be designing this set of rules? And we submit not. They are and they should be for Parliament, and it can, and indeed has in fact answered the when and for how long questions in legislation when they've chosen to do so. And all of that, all of those submissions we submit are thrown into stark relief by the very recent events that have occurred. And I make only 2 points in relation to those recent events. First, there was always going to be, and there will be, sittings affording opportunities for Parliament to express its will and to legislate as it chooses. Section 3 was enacted, and the significance of it being enacted is that it and the other pieces of legislation that I took you to in our case indicate that when Parliament wishes to control sittings, it's made specific provision for doing so. And it has in fact made specific and detailed provision for precisely that, with Brexit and its dates very well in mind through the Anderson Amendment in Section 3. It could have made different provision if that's what it wanted to do. It didn't do so. And it illustrates also, Section 3, that there are legislative judgments that are involved in making that sort of legislation, about which Parliament is the only judge. When, for how long, how do you come back, for what period, what are the principled and procedural controls? And the key point is that at the heart of these claims is an invitation to the court to enter territory through the principles of judicial review with a view to the legal imposition of additional controls to those specifically enacted in Section 3, with Brexit clearly in mind. Additional controls. Secondly, the centrepiece of the claim was, and I think remains, despite the attempt to broaden it out, the contention that prorogation was intended to have and has had the effect of depriving Parliament of an or a sufficient ability to legislate specifically in relation to what were perceived to be the consequences of a no-deal Brexit on the 31st. And the events during the course of the hearing before the Divisional Court in the Inner House and that have occurred subsequently demonstrate precisely why and how that is untenable, in fact. Parliament has had and has taken the opportunity to legislate. It has done so in the new Act, and so there are now primary legislative controls over exit with a deal, 2018 Act, exit without a deal, extension, and all of that is covered by primary legislation. So Parliament has legislated for all of those things. And if it's said that more time is going to be needed, i.e. beyond the period up to 9th of September and before 14th of October, two questions arise, and they're the same basic two questions. How is the court to determine that question? How much more time should Parliament have been afforded? And how is it appropriate for the court to do so when Parliament has legislated, as it has in Section 3, so as to require, in effect, additional sittings to those specifically provided for in the primary legislation? And there could, of course, have been further legislative provision even in the new 2019 Act. There could, even before you got there, have been before, in that week leading up to the prorogation on the 9th of September, there could, of course, have been a motion of no confidence. But if Parliament had wished, when it enacted the new Act, if I can call it that, to produce a provision requiring that Parliament should sit during the period of prorogation, they could have said so. No such provision was even in the bill. And it's no answer to that to say Queen's consent. Whether Queen's consent is actually needed for a bill is a matter for Parliament and the Speaker, and the courts cannot make any assumption that it would be needed. We note that it was not a provision, it was not needed and was not sought for the enactment of Section 3. And nor can the court assume, if this was the implication or suggestion of Lord Pannick's submissions, that even if it had been needed, it would not have been sought or obtained. You can simply make no assumptions about that at all. The fact of the matter is that Parliament had the opportunity, if it had wished to do so, to legislate not merely to control the undesirable, perceived undesirable consequences of a no-deal Brexit. It could have said, and by the way, if and to the extent that Parliament is going to be prorogued next week, we think we need more time. But it didn't do that. Can I turn briefly, and it is, I'm afraid, going to be briefly because of timing and because no one is mounting a challenge in this case that it should have been the 9th. I'm going to give the Section 3 and how it works issue. I'm going to try and grapple with that briefly, but there isn't a direct issue before you about that, so I'm going to take it tolerably shortly if I may. You find the provision itself behind tab 59 in bundle 3 of the authorities, of our authorities. If it helps to give the Cherry MS number, I don't know if that is helpful, 2951. Thank you. Bundle 3, tab 59, my lord.
I don't think our bundle 3 is up to that.
Oh, maybe bundle 4? I'm so sorry. Yes, sorry, it's bundle 4. I'm sorry.
What was the Cherry number, please?
2951, my lady.
It is.
Do you see the basic structure of the section? It's to produce reports, to publish or make reports. I think in sub 1 it's publish, in sub 5 it's make, but it matters not. You've got to produce a report The first one's got to be produced on the 4th of September. The second one's got to be produced on or before the 9th of October. That's sub 5. And the one that is produced on the 9th of October will be a report under subsection 1. Yes? So, go back to the rules that would apply to the first report, or did apply to the first report, produced on the 4th of September, and then 2 cuts in. The Secretary of State, 2 and 3 together cut in. Secretary of State must make arrangements for a copy to be laid on the same day it's published. That's 2A. And then motions moved in the Commons and the Lords, 2B and 2C. And those have to be moved in the relevant House, see sub 3, within a period of 5 calendar days, beginning with the end of the day on which the report is laid before Parliament. Right, so that's what happens in the ordinary scenario. But then 3.4 is the critical provision for present purposes. It specifically contemplates, as you see, the possibility that when such a report, either 4th of September or subsequent reports, because they're all Section 1 reports, when a report is published, Parliament will stand prorogued or adjourned. So it's making very specific provision for what happens when Parliament stands prorogued. Let's leave aside adjournment for simplicity. And in that set of circumstances, the bespoke rules that are set out in 4 apply. And the first obligation that then happens is that the Minister of the Crown can't comply with the obligations under 2 and 3. So this is specifically contemplating that as a result of the prorogation, despite having published the report under 1, there will not be an opportunity or the possibility of either laying or moving the motions. And in that set of circumstances, i.e. recognising that you can't, for the purpose of this set of sections, lay in this way, what then is to happen to complete those steps? That's what 4 is about. And the first thing that happens is you've got to get Parliament back. A proclamation under the Meeting of Parliament Act 1797 shall require Parliament to meet on a specified day within the period within which compliance with subsection 3 is required.
What are the mechanics of that? Would the Prime Minister have to ask the Queen to
make a proclamation? Yeah. No. Not sure is the answer to that.
Well, it's not all that.
No, but anyway, it's you've got the day within the period within which compliance with 3 is required, and that is a period we respectfully submit of 5 calendar days.
Mm-hmm. Your point is all of this could have been translated to a wider provision, or a different provision, and Parliament chose not to do that.
My point about how this works, I think this is what I'm really trying to address is...
I think you're going to say that it only requires compliance within a period of subsection 3 and not subsection 2, but the problem with that submission is that 3 depends upon a day on which the report is laid before Parliament, which takes you back to 2.
Well, that's true, but that's just simply being used to define the period. So we take for this purpose the day of laying as being the date of publication, and you still get a period of 5 days for compliance with sub 3 from then.
How can the date of publication be the date of laying when you can't lay?
Well, you have to have something because it's recognising earlier on in the subsection that you can't comply with 2 or 3, and 2 is about laying. So the only way of making it work sensibly is that. Does that make sense? That's the...
Yes.
And then you have a period of 5 working days thereafter.
In the limitations of this, yes, it makes sense.
Yeah.
Yes. Yes, so you say because the second report had to come in on the 9th of October, subsection 4 allowed the government to prorogue until the 14th of October.
Exactly so.
The end of the 5 days.
Exactly so. And then, pursuant to the provisions of this, and I agree, it's slightly odd wording, it is required after sub 3 and 4, but otherwise it works worse the other way, if that makes sense. So this is a way of making it work sensibly. That means that you set your period, and it refers to a period, by the way, so it's got to be a period which is referred to. It's the 5 calendar day period, and there's a strangeness, or perhaps a felicity, in the 3 uses calendar days, and then there's working days at the end of 4. But you do your 5-day period for that, and then you have 5 working days within which to debate. And what that effectively does is set a mechanism by which Parliament, and no doubt the 5 calendar day period is a sensible one, because it will require some mechanics to be gone through to get Parliament back to do the laying and all of that.
So you say Parliament wished to be in session from the 14th and 5 days thereafter?
Exactly. That's how we say it works. But I emphasise, this isn't no one's queried this isn't an issue in this litigation.
Do you say there are any restrictions on the subject matter of debate?
I would know. 5 working days. And that's why you had the 4th of September and the prorogation happened on the 9th. I mean, this was set. The period of prorogation was evidently set by reference to the primary, it goes back to a point I was asked earlier, by reference to the primary legislative controls that applied. But with that interpretation, with that view being taken about how it operates at the end, which was my Lady Blank. I hope that's of some.
This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service.